This case is being live streamed. It is an appeal in proceedings concerning children. Accordingly, I make the usual order that any report of this case must not name the parents or the children or their respective addresses or the children's schools. Thank you. Yes.
My Lord knows that there are two appeals and one application to be dealt with today. First appeal, of course, is that of my client, the father, the husband, against the order of Sir Jonathan Cohen of the 13th of May, summarily dismissing the father's applications for a stay, to set aside the order recognising, for the purposes of the Hague Convention, the Russian judge's order made on the 18th of May, and for orders in his fresh application under the Children Act, in relation to the younger child, to whom I shall refer as child 2. Secondly, then, there is the mother's separate appeal, also against the same order but two different parts of it, which provided, so far as relevant, first for the provision by the 31st of May of written submissions in relation to the contact arrangements between the father and child 2 if the parties were unable to reach agreement, explicitly so that the judge could rule on the appropriate arrangements, and secondly against the judge's order directing the return of child 2 to the jurisdiction between the 15th and the 26th of June. She was still in England at the time, but it was anticipated that she would leave for Russia.
The submissions were directed to, so I've lost the order, were directed to the question of contact in June and July.
Yes.
Yes, thank you.
And then separately there is the application still for permission to appeal, brought by the father against the order of Sir Jonathan Cohen of the 10th of June. My Lord Justice Moylan has dismissed two of the grounds of that proposed appeal, adjourning the third ground, complaining of the refusal to make a legal costs funding order in relation to children matters. That application to be heard at the end of this hearing.
Yes, so we'll deal with the first two appeals, and then at the end of that, if we have time, deal with the
Lord, yes.
adjourned PTA. Thank you.
In relation to the presentation of those appeals, at the bar we have reached agreement about how best to do it, subject of course to your lordship's agreement or otherwise. We propose that I will speak to the father's appeal.
Yes.
Mr. Gupta, on behalf of the mother, will speak in opposition to that and in support of his appeal. If Mr. Hames is to make representations, that would be the time for it to take place, because of course he supports the mother's position, subject to possible caveats almost entirely. And then Mr. Deverick's Queen Counsel will speak in opposition to the mother's appeal.
Right.
And then if we have time, of course, we'll deal with the legal costs funding order aspect. Lord, I know we'll have had some time with the papers.
Yes.
So I'll deal with the background.
You'll reply on the father's appeal if you want to.
Yes, thank you. Yes. Whether Mr. Gupta also then replies on the mother's appeal, we can see in due course. But that seems to us the most efficient way to deal with.
Yeah.
So the background, if I may, I'll deal with it relatively speedily, because I know my lordships will have had time with the papers. It's important to note that the proceedings have been underway in this jurisdiction since the autumn of 2020. Firstly, divorce proceedings, although after the wife obtained a first-in-time divorce in the Russian Federation, we say in breach of the Humane injunction, then Part 3 proceedings under the Matrimonial and Financial Proceedings Act. And proceedings in relation to the children in this jurisdiction since November 2020. My Lords will have seen at various points reference to what we have called Orders A and B. I may have unpicked the strange situation whereby in the Russian Federation, the mother's returned unissued application for want of jurisdiction, leaving the father's application first in England, first in time for lis pendens purposes, was then the subject of an appeal in Russia. The appeal was successful. The matter was remitted to a judge at first instance. And bizarrely, we say, on the same day, the 20th of January last year, 2 orders were seemingly made by the same judge in Russia. One of them, with the case number on the order, returned the mother's application again, unissued. The other order, same judge, no case number included on it, purported to accept and issue the application. The relevance is this: since then, the mother's application has proceeded in Russia as though it had started by the first-in-time claim. The father's case has always been that the order returning the claim, Order A, being properly numbered, is the correct order, and that its very existence must have been suppressed either by or on behalf of the mother. My Lords would have seen that Sir Jonathan Cohen didn't accept that version of events and was prepared to accept a letter from the chairman of the relevant Russian court, who understand not to be a judicial role but a more administrative role, in which it was said that the properly numbered order returning the claim was a draft and was wrongly sewn into the court file. The procedural history then secondary to that development in this jurisdiction has been somewhat convoluted. My Lords will know that Mr. Cosworth Queen's Counsel, sitting at first instance, made an order staying the father's children case on the basis of what looked to be the mother's first-in-time claim in Russia, purportedly pursuant to Article 13 of the 96 Convention. This court, I know Moylan was part of the Constitution, intervened and concluded that Brussels II revised prevailed in relation to the jurisdictional arrangements for the case over Hague 96, and held that if the children were habitually resident in England at the time of the father's application, then Article 13 of Hague couldn't operate, so as to require the English court to abstain from exercising its jurisdiction. The matter then became, or that issue became perhaps somewhat academic as the mother obtained final orders in Russia, vesting custody of the children in her and giving her the power to decide where they should live. Lords, it's only right that I say at this stage that the father's case has always been that the obtaining of final orders in Russia came via a wholly unfair process. He's pointed to the occasions on which the Russian court, he would say inexplicably, has made rulings in the mother's favour. For example, to proceed to hear important witnesses in the absence of his Russian lawyer through illness, notwithstanding an application to adjourn. For example, not allowing those witnesses to be recalled for questioning when his lawyer returned to health.
Mr. Tyler, I appreciate all this. These matters were dealt with in the judgment.
Yes.
So we're aware of those, of January 2022.
Well, yes. I don't say them for no reason, because it comes, we say, into the evaluative exercise which ought to have taken place at the hearing of which we complain. But I'll do them in shorthand, knowing that my Lords understand them. We make complaint, for example, of the speed with which the letter from the chairman of the Russian court to which I referred was obtained, and we point to the vast wealth and prominence of the mother and her family in the area in which the courts were sitting. The final order having been obtained in Russia, of course, the case became one of recognition and enforcement, not primary jurisdiction. And my Lords know that the case was heard over a couple of weeks by Sir Jonathan Cohen in November of last year. My Lords would have seen in that judgment, which came out in January, that his Lordship concluded that the children had been habitually resident in Russia, not England, at the point of the father's application in November, and when asked to clarify his judgment, also at the point of the mother's application for enforcement in June 2021, which we said was the relevant date. And also have seen that the reasoning for that latter finding is contained in in one paragraph, paragraph 120. The learned judge further concluded that the father hadn't been successful in establishing any of the Article 23 grounds for refusal of recognition, and effectively we were arguing that public policy militated against recognition of the order, effectively for those reasons I've set out in shorthand, which we set out rather more lengthily at that hearing. Accordingly, the Russian order was recognised, corollary orders were made. Lords know that a stay was put in place until a fortnight after this court decided the application for permission to appeal, or otherwise disposed of the appeal, that my Lord Justice Moylan dismissed the application for permission on paper on the 14th of April this year. The mother applied by email, without copying others in, for release of her passports. The matter was dealt with on an inter partes basis, and an order was made on the 28th of April, releasing those passports at a subsequent point. On the 12th of May, the father issued 3 applications, the dismissal of which forms the basis of his current appeal. Application to set aside the order releasing the passports, to stay the order releasing the passports, to set aside the recognition order, and orders under freshly issued 1989 Children Act proceedings. The 13th of May, the next day, saw Sir Jonathan dealing with those applications, dismissing them. The hearing submissions took something like an hour, and I'll take my lord to the judgment in due course. But whilst
I've read somewhere that it was listed for an hour and lasted for 2, but that may be mixing it up with another.
Well, I've read that. I've also read that submissions were about an hour. I don't know how much
Right.
time was taken up in judgment, but it was that sort of order of magnitude. On the 17th of May, my Lord Justice Moylan extended the stay in relation to the release of the passports, and the reasons given in the order extending that stay were, quote, the proposed appeal would be significantly prejudiced, if not in part rendered nugatory, if a stay was not granted. Accordingly, the prejudice caused by a stay is outweighed by the prejudice which would be caused if a stay was not granted. And whilst it's not our part to put words into the Lord's mouth or pen, it seems abundantly clear that what was meant by that is that the mother should not remove child 2 from this jurisdiction whilst the appeal was pending. On the 18th of May, we think, the mother did remove child 2 from the jurisdiction. Various orders were obtained, but too late. And my lords may have seen the mother's statement in the first supplemental bundle, explaining effectively that she did that not in direct breach of any order, making no apology, expressing no remorse, making no reference to the fact, which we say must have been obvious, that the removal was in contravention, at least to the intention of my lord when extending the stay. And it's clear that the documents exhibited to that statement don't satisfy the list directed by Mr. Justice Moore to be included. That's the reason why I've had to say, I think, after reference to the date on which she left the jurisdiction, we haven't been able to fact check what she said about the issue. She said that she obtained travel documents from the Russian embassy in circumstances in which she wasn't entitled to have child 2's passport released to her. The father issued an application for permission to appeal against Sir Jonathan's order. The mother issued hers. On the 1st of July, my Lord Moylan granted permission in relation to those 2 applications, and here we are, as it were. The other relevant information is simply to say that the parties spent all of last week involved in a lengthy hearing in the Part 3 proceedings, which are being heard by Sir Jonathan Cohen. the mother the mother makes in her written documents what is called a ladder marshal application. I say it's called that because whilst it talks of seeking permission to adduce evidence, I've not seen any evidence which it is said should be adduced. I've simply seen reference to two incidents which it said ought to be before the court. If I may, I'll deal with that if the application is made and pursued. The father's appeal then, perhaps the starting point is the original judgment of Sir Jonathan Cohen. I ought to have introduced the various bundles that my lords have. I'm sorry that they've proliferated so much. You have, I hope, the main appeal bundle, the legal costs funding order application bundle.
Wait a minute. What's that titled? I think I do, but
Permission to appeal bundle, I think.
Index court bundle for permission to appeal.
Yes.
Yes.
So that then a supplemental bundle containing half a dozen further documents, including, for example, the statement produced by the mother as ordered by Mr. Moore.
1st of June 22. That
Yes.
statement. Yes.
Then a second supplemental bundle
Yes.
containing the transcript of the 10th of June hearing,
Yes.
only very, very recently received.
Yes.
I think possibly only today, a transcript of the
13th
of May proceedings.
Yes.
And I think, and I'm sorry for this, that all of our skeleton arguments, which number 5 or 6, that is to say, one for 3 of us in the children appeals, one from 2 of us in the funding application, and one from Mr. Gupta in relation to life funding, are all separate documents.
Wait a minute. Can I just go through those? So far as the skeletons for what I call the substantive appeals, we have a skeleton from you and Mr. Deverett dated 20th of July.
Yes.
We have a skeleton on behalf of the mother from Mr. Gupta, Ms. Perrins and Miss Renton. And we have the skeleton filed by Mr. Hayes. Yes?
Yes.
And Miss Brigadier. So far as the permission to appeal is concerned, I have a skeleton from you dated 21st of July.
Yes.
I have objection. So what else should I have in respect of, or should we have in respect of that?
A 6-page skeleton argument from Mr. Gupta, Queen's Counsel, entitled Skeleton Argument on behalf of then first respondent mother.
Right. I don't think I have that, speaking for myself.
No, there were lots of typographical errors and we sent it in twice, so we'll get that.
Could you get, because I don't, from what my colleague said, I don't think we've got that. So and that's all of them.
That's all apart from the submissions already dealt with in relation to live streaming.
Yep.
And then, just to annoy the panel even more, I think we have produced authorities bundles in 3 separate tranches without repetition, but mothers first, those of father not included in that second.
Yes, and then a third too.
This morning,
yes.
I think a couple of cases on behalf of Anastasia.
Right, thank you.
Yeah, our apologies for the piecemeal way in which those come before, my lords. So dealing with the father's appeal, as I say, perhaps taking as a starting point the original judgment, my lords will find that at paragraph 97, page 140 in the main bundle.
Yes.
forgive me, are my lords all working on paper copies or hard copies or a combination?
Combination.
Would it help to have the printed number at the bottom or the electronic number, or both when I take my lords to pages?
They're the same, aren't they? Page 140, you said?
It's page 140 printed in my PDF.
Yes, well, that's right. We just add 8.
Is page...
Some people manage to put together bundles where the numbers are the same,
Yes,
but they're rare.
yes.
Give the paper one, then we hit a problem,
Yes.
because I've got the paper one. So let's give the paper one.
Well, it's
Right, page 140.
Yes, in brackets, add 8 if working electronically. So page 140 deals with the question of recognition and enforcement of
Yes.
first instance. So one sees at paragraph 97 that his lordship set out entirely, usually, the wording of Article 23 of the Convention. Subparagraph 2 of that article, recognition may be refused, and principally important to our applications has been if such recognition is manifestly contrary to public policy of the requested state, taking into account the best interests of the child. We also took issue with various aspects of the Russian proceedings and whether in fact the father had a proper chance to be heard, but they're probably better dealt with as subcomponents of a public policy argument rather than freestanding objections in their own right. My lords see then over the page that his lordship summarised our case at first instance, that Russian proceedings were so unfair and or corrupt that the court ought to refuse them. He set out in the next few paragraphs the fact that on his reading both parties had been, looking at the end of paragraph 101, neither's presentation was full or accurate in their early dealings with the Russian courts. He deals with orders A and B, paragraphs 103 to 105. At paragraph 110 then, his lordship sets out the principal components of our then argument in relation to the court process, and I know my lords have seen this, so I seem to refer to them tangentially. Paragraph 110.1, the absence of the father's representative when applications were dealt with. Subparagraph 2, the fact that in breach of a direction to apply to adjourn the Russian proceedings, that application was made in such a way that it seems to us clear that it wasn't meant. Paragraph 111, one sees his lordship's reference to the rejection of the adjournment. Paragraph 113, we say is relevant to refer to again tangentially because it will play into something else I say in due course. That during those proceedings, child 1, who had been joined as a party given her age, inputted her views, recorded as a desire to continue living with her mother, her wish to move back to the part of Russia where the family came from, to finish school. So for presumably the last 2 years of school, possibly the end of this year, which has just finished now, and then to move to another city in Russia for her tertiary education. Paragraph 114, one sees reference to the fact that the application to recall witnesses was refused in Russia. And then at paragraph 117, his lordship refers himself to the fact that the test of refusal due to public policy is a high one. Would recognition be manifestly contrary to the public policy of England and Wales, taking into account the best interests of the children? And the second and third grounds I've referred to are perhaps of less significance for current purposes. Paragraph 120, one sees his lordship's dealing with an issue that caused us some difficulty throughout, which is this. We said that there's plenty of good quality research, peer-reviewed publications, information from NGOs, etc., to demonstrate the difficulties with the administration of justice in the Russian Federation. Beyond producing that sort of material, it's virtually impossible to produce actual evidence suggesting difficulties. Paragraph 121, his lordship reminded himself again of the test before then at 122, setting out the core findings. I don't accept his, that's my assertions, that the Russian proceedings were biased and or the mother was able improperly to influence the course of those proceedings. The Russian court failed to adhere to the basic principles of natural justice. The Russian proceedings failed to ensure the effective participation of A and child 1 and 2, and the Russian proceedings failed to take account of child 2's position. Having not accepted those assertions, it followed that the objections, the possible objections under the 96 Convention weren't made out, and thus it was the orders were recognised. Paragraph 123, one sees his lordship dealing with our assertion on the father's behalf that in the event that the children were to return to Russia, then he, the father, would be effectively written out of their lives by the mother denying him contact and or obtaining orders from the Russian court which will have that effect. His lordship recorded that the mother denied any such intention, and his lordship found, I can see no reason why this should be the case, referring to the fact that, first of all, there has been contact whilst the parties and children have been in London, and secondly, there's no reason effectively why the father couldn't travel to Russia, A, to have contact, or B, to pursue any claim in relation to the children in Russia. The subsidiary argument of paragraph 125 is one of the issues which was dealt with effectively by my Lord Moylan, refusing permission to appeal against those findings, that judgment. If one fast forwards then in the proceedings, and we will have seen that the father changed solicitors shortly before this was done, he prepared a statement in support of his application to set aside the recognition order of Sir Jonathan, which you'll find, I think, at page 285. The statement was prepared relatively hurriedly and by solicitors not then in possession of all of the papers, but set out the father's case.
12th of May.
I'm so sorry.
12th of May.
Yes.
Yep.
One sees at paragraph 4, for example, change solicitors. New solicitors not in possession of all the papers, not intending to draft a full statement for me to provide in support of my application. This is therefore by necessity a short statement, and I reserve the right to file a fuller and more detailed statement in due course. So the issues of which he, the father, complained, or
Just to keep up, is this the current solicitors or the previous solicitors?
this is the previous solicitors,
The immediately previous solicitors?
immediately previous solicitors. Thus it was that the statement sets out in relatively shorthand terms the matters which the father said cumulatively represented a sufficiently significant change in circumstances to undermine the basis on which the original recognition order had taken place. Referring first of all to the geopolitical events, which he said, one sees there in the list at 6A, impacted on child's ability to see him and communicate with him in Russia, referring to what he said was the mother's failing to promote her relationship with him, referring to the likely inability of child 2, and we can't say much more than that, to leave Russia, see his likely inability to obtain appropriate orders in the Russian courts, for the weight and efficacy of Russian orders within the international community. 5, the real and present danger of his prosecution and the danger to him in Russia of the lack of rights to freedom of thought and expression. And sixthly, or ultimately, so perhaps deriving from the first five, whether the order should in fact be recognised in this country. And then those headlines are fleshed out to a certain extent in the paragraphs which follow. Paragraph 8, one sees reference to the uncontroversial assertion in relation to the military operation of the Russian Federation in Ukraine. But the father went on throughout that paragraph to set out ways in which that might impact on him. He talks of a culture of fear and introspection in the Federation. He talks of people having been placed in power who supported the views of the president and who would be rewarded with financial gain and power. He makes the assertion that the mother and her family are just such persons. And he makes reference to the use of the mother's family of their power and influence in Russia. First of all, to influence the court process, and I recognise and will deal in a moment with the fact that thus far that assertion gained little traction with Sir Jonathan. And an assertion that the mother has made it clear that she is prepared to use authorities in her favour. And references, for example, Moylan makes in reference to this, the strange fact that the mother was able to obtain a letter from a chief of police effectively bad-mouthing the father, notwithstanding that he, the police chief, had no knowledge of him. The broader point the father makes at paragraph 10, whilst it's broad in its scope, of course, applies to him as well as other individuals specifically. He says in terms that his stated position in relation to the military operation is such that he is in real jeopardy, if he returns to Russia, of effectively arbitrary imprisonment or worse. He goes on in paragraph 11 to make the point that even if he tried to be unobtrusive, there's nothing he could do to prevent powerful members of the mother's family from causing difficulties for him in Russia, and points to the fact that, so far as he's concerned, she's done that in England, and secondly, that it's universally acknowledged now, even if the articles we produced at the time weren't accepted, that justice can effectively be bought in Russia. The father goes on then to speak about the international reaction to the Russian invasion. Again, relatively uncontroversial insofar as they represent things which have happened, but of pretty huge significance when considering, for example, questions of comity and the underlying rationale for conventions such as the 96 Convention, that organisations such as Amnesty have intervened in the way they have. The Federation has been excluded from the Council of Europe. The UN General Assembly voted to suspend Russia from its seat on the UN Human Rights Council. And of course, the fact that there are well-publicised cases of those who have come to harm, it seems universally internationally accepted because of their opposition to the Russian institution. Paragraph 18, the father makes reference to the fact that far from the position being as had been stated both to the Russian court and to the English court, and referable firstly to where she should live, but secondly to questions of habitual residence, child one, far from being about to embark on the end of her education in Russia, intends to do so at the school in England, at which she's been educated for some time now. That remains, as we understand it, to be the position. And one sees, we would say, relatively unconvincing explanations for what is described as a change in mind, but in fact, we say is, or at least may be, and this should be explored in evidence, an expression of what's always been the intention, coupled with a previous attempt to hide that fact from the court. And in paragraph 19, one sees in relation to child 2 the assertion that that child is significantly upset by what is proposed. And those matters then are dealt with further through that statement. So, pausing there, we would say that though some of those submissions, some of those assertions can be reduced to relatively short headlines, they are, some of them, of the highest moment. The father says, in terms, in that document, if I return to Russia to take up contact with a child whom the mother decides will live there, there is every chance I will be the subject of arbitrary detention, arbitrary punishment, possibly without limit of time. And that, if that looks like a remotely unfeasible assertion, the people who would do me harm have very, very, very significant wealth and power in Russia. And in response to Sir Jonathan's saying that the father is someone who sees conspiracies around every corner, there is a plethora of international resource, governments, non-governmental agencies, etc., setting out exactly what is happening arbitrarily to those in Russia who find themselves on the wrong end of the establishment's views as to what ought to happen and what ought to be said. The skeleton argument, our skeleton argument in support of this application, deals with paragraph 40. The way in which Mr. Devereux, who appeared at this hearing, then expanded on the statement and the skeleton argument, which was very similar in its terms, in oral submissions, setting out further complaints that the mother hadn't taken steps she should have taken in Russia to allow the father freely to travel there, steps she should have put in place to allow appropriate contact arrangements, and referred to an application for costs made not only by the mother but by child 1 in relation to the Russian proceedings, in relation to which the father may be in jeopardy if he returned. And as that summarises, the educational needs of child 2, which again seem to have been deliberately or otherwise misrepresented to Sir Jonathan at first instance, were explained there as providing reasons militating against the recognition of the order. We'll also see attached to the father's statement, I'm sorry to flick between bundles, various documents, the first of which at page 295 is and this had been in evidence beforehand, the letter obtained from a police chief in Russia, conveniently criticising the father and, of course, opposed to that provided in relation to the mother. And then sees from page 299 the sort of documents easily available from open source, setting out the position in Russia. Page 304. One sees confirmation from the school.
Sorry, say it again, page
304, my lord.
304, thank you. Yes.
Confirmation from the school in question in relation to various choices made by child 1, demonstrating, first of all, her very likely continuing at that school, but secondly, the fact that those choices were communicated to the school really very shortly after the judgment in January of Sir Jonathan, which was predicated in part on what was then said in relation to Child 1's intentions. And at page 305, one sees recently confirmation that there's been no communication of any intention to remove Child 1 from that school. That continues, as we understand it, to be the case.
So can you just make more explicit what's the point that's being made about the consequences of Child 1 either having the option to study or studying in the UK
Yes.
upon the validity of the original decision?
In a number of ways. Firstly, as Lords know, when habitual residence is a matter of challenge and where there is a genuine choice between more than one jurisdiction, so it's not simply having left A, has one acquired residence in country B, then lots of different sources of evidence go to inform the ultimate decision as to where habitual residence lies. In relation to Child 1, much play was made of the fact that she sees herself as a Russian child, that she has chosen to cease her education in England, which was effectively temporary, in order to take up education both from next school year onwards and at a tertiary level in Russia. So first of all, we say that it's evidence which may well have impacted one way or the other in relation to that exercise. And of course, the older a child, the more their subjective views are referable to the question of habitual residence. The second point is this. We've got no idea currently because the father's never told any of this, but how is this to impact on the relationship between Child 1 and Child 2? It is said that Child 2 is to be educated in Russia, in that part of Russia where the family come from, which is a very long way away from England, whilst Child 1 is to remain living in England. So assuming the broad overlap of school terms, these two siblings, whose being together was an important part of the case, are not to be together. When is Child 2 to see Child 1, assuming she can't travel in the school term time? How is Child 1 properly to be looked after, assuming that the mother will be looking after Child 2 in Russia? The question of public policy potentially militating against recognition is to be viewed through the lens of the child's best interests. And whilst these matters don't, of course, impact on what I've said about the Russian state and the inaccessibility of justice for the father and or the possibility of injustice, they militate towards our suggestion that these orders, if recognised, and if given effect to in the way one never quite knows, but it looks as though the mother is to give effect to them, will act significantly contrary to the children's best interests. So firstly, because Child 2 can't see her father, we say, unless she travels to England to do so. But secondly, when is that to happen? Because much was made of the fact that Child 1 wants to be in Russia as long as she can. If she's schooled here, she wants to spend her holidays in Russia. So when's Child 2 to be brought to this country if in the term time she can't come, and in the holidays her elder sister is in Russia? Thirdly, it goes to the question of good faith. I'll develop this in a moment, but we say that the way in which Sir Jonathan dealt with these issues was simply, in a cursory way, to analyse them separately. Issue 1, not a problem. Issue 2, issue 3, not a problem. Whereas, in fact, given the breadth and potential significance, they should have caused the judge to go back to the principal findings made in January and say, does this remain good? I said in January that there's no suggestion that the mother will seek to exclude the father from children's lives. Now I know X, Y, and Z. Does that remain the case? I said there was no question that he wouldn't have access to Russian courts. Now we know about, for example, the invasion. Does that remain the case? So we said at a number of different levels, these vignettes impact on the exercise which should have taken place at the summary hearing effectively in May.
Do you mind if I ask you at this point what the consequences of your argument being successful might be? By this appeal, you seek another hearing in front of a different judge.
Well, our principal submission is that this court is in a position today to set aside the order of recognition. If that was done on a final basis effectively, then it would give rise...
I thought one of your main arguments was that it had been dealt with too cursorily by the judge.
Yes.
So, I mean, just putting this rhetorically to you, how could we possibly embark upon such an exercise?
Well, because...
appeal court?
Yes, well, I understand and expected the question. The answer simply because already this court has applied more time and attention to the question, has read skeleton arguments, has seen the evidence, will have heard a day of submissions, and so will be in a better position. If any of, we would say, our new points are effectively killer points, i.e., this man, or this court cannot have any confidence that this father is able safely to travel to the country where his daughter is to be living if the order is recognised, then that on its own would be enough, we say, to set aside the basis on which it was made. The Lord is entirely right. If this court says no, a summary assessment is what happened, that can't take place now, then yes, we say that this ought to be remitted to a judge at first instance.
Well, I raise this with you because I thought your point was that because of all the matters that had been erased, a summary assessment was not appropriate.
Yes.
And so that, as I think you partly accept, rather speaks against a summary assessment carried out by this court as well as by any other court. But you're now going on to what happens if it's remitted.
Yes.
You have another hearing, whether it lasts 10 days or 7 days or whatever it is. At the end of that, you succeed in establishing non-recognition of the Russian order.
Yes.
What happens next?
We would, in doing so, well, we would seek to establish jurisdiction, current jurisdiction in this country.
Yes.
And of course, there's nothing to prevent Hague 6 or otherwise there from being proceedings in this country. We would say that at the point that the May application was made, unquestionably, Child 2 was habitually resident here. The English court has power then to make such orders as it chooses.
The English order then says the children should be brought to England?
Yes. With the child, yes. Child 2. And to the argument then in relation, potential argument to enforceability.
So you say just Child 2?
Well, Child 1 is...
16.
Well, first of all, she's of an age that would prevent orders being made unless exceptionally. And secondly, we understand, but it's not been properly confirmed,
Not quite sure.
that she is to be in England anyway, certainly for school.
Right, so it's all about Child 2, in that case by this stage, at least.
The proceedings are Child 2, assuming we're right about Child 1's education, then that of course will impact significantly on decision making in
But I mean,
relation.
the reality is that it would be accepted that whether she achieved, as she would, 16 or not, that Child 1 is beyond the reach of the sort of orders that you might have wished.
Yes,
Right, so it's all about Child 2.
yes,
And at that point, you face a situation where you're seeking to obtain and then, if necessary, enforce orders for Child 2 to be in this country.
yes. In circumstances in which, A, she oughtn't to have been removed from this country, and was removed, we say, certainly in contravention of the intention behind
Yes,
an order.
I follow
And
that,
secondly,
but
in which,
against the backdrop of everything that appears in your client's statement.
yes. And to the potential issue in relation to enforceability, of course, we have ongoing Part 3 proceedings in this country, which have the potential significantly to assist in the power of a court to insist on its orders being enforced. In any event, we would say that the court oughtn't to, this is for the next call, not for this call, but the court oughtn't to decline to make orders which are potentially enforceable simply because of fear of them not being enforced. On any view, this is a family with significant links to this country, such that, for example, we argued with some confidence that the children were at the relevant time habitually resident here.
Thank you.
But my Lord, if I may, the case as it's developed over months and months has had so many twists and turns that we would say...
It isn't twists and turns, it's digging and digging.
Well, but not always in the same direction.
Yes. But anyhow, that's the
Yes.
the road ahead.
We would say this: if the orders, Russian orders, were recognised on a basis which is now undermined, then the appropriate course is for them to be set aside, or at least for the refusal to set them aside to be overturned, the question to be remitted to first instance. And at first instance, whether it's to look at set aside or to look at the consequences of set aside, then that is where the sort of obvious issues which will arise, which will all make reference, ought judicially to be grappled with. But it would be wrong, we say, to refuse effectively our appeal on the basis that there may be difficulties further down the line.
I understand that. I just wanted to situate your legal submissions in,
Yes.
in the real world.
So, my Lord, I think I'd got as far as making reference to the oral submissions that were made before Sir Jonathan.
So the focus of your submissions or the target is your case, putting it broadly, that your client has a sufficiently arguable case that the new matters that were referred to in his statement and in the oral submissions and anything else you're coming to now were such that it was wrong for the court summarily to dismiss his application to reopen, or for the court to reconsider its recognition of the order, because he had an arguable case that the new matters were such that the court might come to the conclusion that it was manifestly contrary to public policy
Yes.
to recognise the orders. Is that how it goes?
Yes, exactly. And that, given, yes, I suppose a subsidiary, given the complexity of the issues, geopolitical and otherwise, given the fact that the public policy non-recognition argument is cumulative rather than one particular assertion, then all the more it's inappropriate for the judge summarily to dismiss the application, because in fact it was beholden on him, on his lordship, properly to factor the newly learnt information into the process by which he reached his previous conclusions. And in relation to fairly significant pillars, for example, can the father travel to Russia? Can the father achieve justice in Russia? Is the mother motivated to support or to do all she can to frustrate contact between child 2 and the father? Each of those three pillars, we say, is highly significant. If we make out all of them, then we would say unquestionably the orders shouldn't be recognised as being manifestly contrary to public policy, assessed through or with reference to the subject child's best interests. And as if one turns to the way in which, in fact, his lordship dealt with these issues. and the judgment is at page 69.
Yes.
One sees, we say, entirely consistently with what I've said, that the judge effectively picks off each of these issues. Page 71, paragraph 6. The argument then advanced at both big picture and small picture level, as it was put, are summarised. I will deal with those points, the judge says at paragraph 7. He makes reference to the fact that his dealing with them at that hearing, and so summarily, was contrary to the way in which the father advanced that the case ought to be dealt with. Quote, was looking to see whether it is that the father has effectively reached first base with his application. Paragraph 10 deals effectively with dismissal of what is, on any view, a pretty significant assertion, if correct, and would need fairly careful thought that somebody could not safely travel to a country in order to take up contact by simply saying, I don't have before me any evidence the father's ever come to the notice of the authorities that he's in any sense a dissident, always involved himself in any form of political activity. I don't accept there's any particular risk. On any view, for example, the disclosure of his statement in support of the set-aside application would provide prima facie reason for Russian authorities to form the view that the father, in a public forum, was effectively speaking out against them. There's been so much reporting of the ways in which individuals, large groups of individuals have been dealt with, that we say it isn't remotely fanciful to hold that possibility up as something which the father properly fears. The conclusion at paragraph 11, I don't accept there is any restriction on the father visiting Russia, or there's any political risk if he were to do so, or that in any other way his liberty is at risk by reason of false allegations. With the greatest respect, we assert that that finding simply is not open to the judge, having read what the father has written, having seen what's happened in the world over the last then 3 or 4 months, and having undertaken a hearing in which the father's counsel had 30, 40 minutes or so in which to make the applications. Paragraph 14, the small picture points are considered, and again effectively dismissed. But nowhere there is there any real assessment of whether there's justification in the father saying your previous views about the mother's good faith can't now bear the water you would otherwise put in them. Simply one by one, these relatively few incidents are dealt with. The conclusion then, paragraph 22, is simply, I'm not satisfied the father's produced any argument that would pass the test for a reopening of the order that I've made, and I therefore dismiss the applications. Because this is in the context of the father's evidence, such as it was, that single statement explicitly saying, I haven't had time to do what I need to do. I fully understand that there needs to be more evidence, and we would say that there would need to be proper consideration of whether and the extent to which someone in the father's position might in fact find himself in jeopardy in Russia.
Why do you say say in parentheses, I haven't had time to do what I need to do? The original order was made in January. Permission to appeal was refused in April. hearing on the 28th of April, in which contact was corrected, and the move of child to Russia was anticipated, and a return visit similarly anticipated by her. The point that the judge was making at the beginning of his analysis was the last minute point. So what is it that would allow your client to say, I haven't had time to put my case together? The judge considered, as he said so, that this was an application that was made at the last minute in the face of preparations that were now well advanced.
Yes.
So why was this case, which was available since at least February, being made at the last minute?
Well, I don't think I know the answer to that. I'd point to the fact that there were new solicitors on board. I'd point to the fact...
If you choose to change your solicitor with this level of regularity, there are consequences. But the judge considered clearly that this was a last-ditch application made at a very late stage. I'm just trying to understand how any weight could be given to the thought, well, I didn't have time to make this case.
Well, we've consistently said that access to appropriate funds to progress the children matters after the recognition order has been such that the fathers not even been on the same playing field as the mother, regardless of the gradient of that playing field. It's been a constant battle for money to be found. And Lord is right, clearly the judge did think it was a last-ditch attempt, and in some senses it was. The child was about to be taken to Russia in circumstances where, Lord knows the father's case, I won't repeat it, he says he would be effectively prevented from having a relationship with her. And the applications were made. But the fact that they were made, even if possibly they could have been made earlier, even if that meant pro bono acting by those representing, if that was possible, the fact they could have been made earlier doesn't reduce, we would say, the significance of the underlying assertions made in that application. And it looks, we would say, as though the characterisation of the judge to which my lord refers at paragraph 6 is entirely consistent with the history of this case. Application has been made at the last possible moment by the father. Perhaps wrongly caused the judge to deal with the applications in the summary way in which he did, when, as we say, the sheer significance of the evidential assertions being made, the sheer significance for this father, and if he's right, the effective, complete curtailment of his relationship with his daughter is such that they had to be dealt with properly.
Do you dissent from what the judge says, which is that if it wasn't dealt with then, it wasn't going to be dealt with before October?
Well,
he says if this was going to be heard, it would be heard in what he described as the Michaelmas term.
We don't know, but we do know that Sir Jonathan has been extremely accommodating in being able to find at short notice, sometimes very short notice, time to hear the parties' applications.
I see. So I mean, although this family is, to coin a phrase, habitually resident in court already, the court is expected to put aside another several days in the lists ahead of other cases.
Lord,
I mean, I realise this doesn't decide whether the judge was right or wrong, but I mean, the practical choice facing him seems to be, number one, to make the decision on the information he had there and then. Number two, to put it in the list so that this family should take its turn, which, if you don't argue otherwise, he's likely to be in a position to know was going to be the autumn. Number three, to ram it in to the prejudice of what other cases there might be.
well, look, bluntly, that those are the unattractive options facing judges all the time in an overworked system.
Exactly, but one has to factor that in deciding how to case manage
Well,
a
yes.
last-minute application of this kind.
Right. And my lord, if his lordship's judgment, if the way in which he dealt with our various big picture and small picture points simply falls on the side of robust but appropriate case management, then our argument fails. We know that. But when we say things have changed so significantly since you made your judgment that the life and or the liberty of one of the parties may be in real jeopardy if it stands, or he will lose entirely a relationship with a young daughter if the order stands, then we say that those difficult choices have to be grappled with in such a way that what follows is an inquiry of more than an hour or so, but a proper inquiry to see whether those assertions can be made good and to see whether the new information in fact impacts on the basis of previous assessment. And by dealing with things possibly understandably in practical circumstances, but in such a summary way, one simply doesn't have an analysis in the judgment which demonstrates that the issues which have been raised, whether or not they could have been raised a little bit earlier, have in fact been considered, analysed and injected into the process of decision making. And that is what we say is objectionable, even if, as I indicate, we all of us, certainly on this bench, and I know on my Lord's bench, recognise the very real pressures facing all levels of court at the moment. But even if eyebrows are raised at the way in which litigation has taken place in this country, a different country, at the levels of fees that have been expended, etc., it wasn't to detract from the fact that on that particular day, it was being said, for these reasons, for these potentially colossal reasons, the order can't stand. And that application required being dealt with as though it were the first application, if it potentially gave rise to the consequences to which it made reference.
I'm terribly sorry, I'm sure it's me, I'm starting to lose the thread. So on the 13th of May, should Sir Jonathan have set aside the order he made in January, or should he have said there's sufficient here to get to first base, so we need to have a full and proper hearing with evidence being filed on both sides?
Well, he ought to have undertaken the process set out in the judgment in, is it B, of going through the four tests to consider how far he got to, rather than just saying, look at these three asserted factors, bang, bang, bang. None of them, in fact, allows me to do what's being asked. And perhaps because of the way in which the proceedings unfolded, the fact that they were listed for an hour, that they'd scarcely been prepared for, in a case management sense, being issued the day beforehand, that process wasn't undertaken. So, my Lord, if Sir Jonathan had thought these issues about liberty, etc., are so significant, of course the order can't stand, then the former set aside. More likely, and I have to accept this, further significant thought and inquiry needed with evidence, and that more likely scenario would have led somehow to time being made available properly to analyse the case that was then confronting the court.
But you said, sorry, you say time being made available as the evidence the judge had was the father's statement and various attachments to it. If I've got it wrong, please tell me. The hearing at which the judge properly considered the matter wouldn't just be so he had lots of time to think about it and hear submissions. It would be to get more evidence
Yes.
to substantiate all
Yes.
the various assertions.
Yes.
Yes, all right.
And of course, one of the principal assertions is that subsequent behaviour demonstrated in a way that hadn't been previously recognised the absence of good faith on the part of the mother, a matter about which wholly properly evidence should have been heard. Our Lord sees the way in which we put it in our skeleton argument, that we say that these freestanding subsequent incidents of which we complain can't be seen in isolation. It comes against a whole list of ways in which we say the mother has behaved towards this court and towards the Russian court in a way which demonstrates the absence of good faith. But one can't simply have a hearing in January or judgment in January saying, I don't make those findings, you've not persuaded me. And then each time a further instance is raised, dismiss that because of the previous finding. Rather, the process by which the original finding was made needs to be unpicked in knowledge of what's happened subsequently. And of course, we now know even since then, the way in which the mother's behaved vis-à-vis this court in relation to the circumstances of leaving the country with child 2. If we were before Sir Jonathan today or a different judge arguing on a remitted hearing, we would say surely that impacts significantly on the assessment of good faith, of preparedness to ensure a relationship, etc. But each time there's a new instance, we can't simply be told, well, I didn't make the findings previously, so that one has to go the same way. At what point does the court say, yes, this does demonstrate bad faith, or yes, if you couldn't rely on internet articles about Russian justice in November, the fact that something as cataclysmic as has happened means that the court can look rather more carefully and with rather more scrutiny at questions, for example, of comity in circumstances in which we've set out.
Hearing on the 13th of May was, as I understand it, a bespoke hearing. It hadn't been listed to happen, and your application, as it were, was dropped into it. It was listed specifically to consider your client's application
Yes.
at a day's notice.
Yes. And Mr. Deverick said in terms, this can't happen summarily at this hearing, and we've all seen the judgment in which Jonathan says, yes, it can and it will, and here's my assessment of your new assertions. Well, maybe I can't say much more about that issue. We'll know the way in which we put our case. There seems to be a challenge made to jurisdiction to set aside a recognition order. Of course, that wasn't argued at first instance and isn't fully argued here. What we would say, though, is that the law seems relatively clear and relatively settled. The starting point is rules 2.1 and 4.1 of the family procedure rules. 2.1, of course, establishes that the family procedure rules apply to the High Court as well as to the family court. And rule 4.1 sets out the general powers of management of a court. First of all, setting out at 4.12, the list of powers in this rule is in addition to any powers given to the court by any other rule or practice direction, or by any other enactment or any powers it may otherwise have. And at 4.16, setting out that among the powers of the court, so except where these rules provide otherwise, the court may, is the rubric at 6, Rule 6 is simply a power of the court under these rules to make an order includes a power to vary or revoke the order. We say that that provides, in the rules, the basis of the jurisdiction, but also that the matter's been considered in the authorities, and the weight of authority clearly comes down on there being a jurisdiction, under inherent jurisdiction, to set aside court's orders, which would include, we say, orders under the 96th Convention, as well as under any other convention or any other power of court. Perhaps the easiest place from which to make that assertion is read W, which I think is in Mr. Hames's authorities bundle.
Yes.
And I see from the composition of that court that I oughtn't to make too bold assertions about what was said or why, but paragraph 66 of that judgment sets out a conclusion, if provisionally expressed, that the High Court has power under the inherent jurisdiction to review and set aside a final order made under the 1980 Convention, exercised when there's been a fundamental change of circumstances which undermines the basis on which the original order was made, and Lord Moylan sets out the reason for that high bar, of course, deriving from people not being able to have a second bite of a cherry or take advantage of a change of mind. The reasoning, we say, in the preceding paragraphs from which my lord derived that, albeit provisionally expressed conclusion, applies no less to any other order, for example, a recognition order under the 96 Convention as to the 1980 Convention. And the rationale for the inherent jurisdiction power existing presumably is simply to give effect to the commonsensical position that if the basis for making an order is undermined by a change of circumstances to such an extent that it oughtn't or wouldn't have been made, then of course there should be power to set it aside. To say otherwise, we would say makes no sense. One can think of many potential examples in which, for example, a significant fact simply was not known at the point an order was recognised. So let's say only the day after the recognition order was made, does a credible fear that the child would be at risk of persecution or torture or imprisonment if he or she returned to X or Y country. This is a hypothetical example. It would be absurd to say that the judge who had heard and recognised the order wouldn't be able to say, well, that's a change of circumstances sufficiently significant to undermine the basis on which I made the order and the basis on which I declined to find it being in the public interest not to recognise it, and would give rise, clearly we say, to the power to set aside. So we say that the same rationale underpins the jurisdiction to set aside a first instance, albeit final, 1996 recognition order, and that being so, the various other case law rules have seen it referred to in my document and others, Tibbles, for example, setting out the circumstances in which a court should be able to set aside ought to apply equally in this case. And the four-stage process to which I referred earlier, one sees perhaps most conveniently in the case of B, which I think is in the mother's authorities.
Yes.
Paragraph 89, I'm usefully told paragraph 135.
Sorry, paragraph 89 you want to take us to.
It's paragraph 89, page 135. In which my Lord Justice Moylan set out a process by which it would be appropriate to decide in relation to setting aside their 1980 convention orders. Stage 1, decide whether to permit any reconsideration. Stage 2, if it does, the extent of any further evidence. 3, decide whether to set aside, and 4, if so, redetermine the substantive application. It's not entirely clear whether Sir Jonathan was undertaking A or an amalgam of A and B. But in any view, we say that taking this more considered approach, which would necessarily take more than the time allotted to the case.
It's A, isn't it?
I'm so sorry.
It's A, isn't it?
So Jonathan only did A.
Yes, I mean, I don't think B gets
No.
into it, does it?
No.
Whether it was right or wrong, he said you didn't get to first base.
Yes. So, Lord, we say that jurisdiction's clearly there, and it's a distraction from this hearing to focus unduly on that. The question comes down to answering the tension raised by my Lord Peter Jackson. Is this a case in which, of necessity, the judge was entitled, possibly obliged, to deal with things very quickly, appropriately reacting to a last-ditch attempt to prevent removal, or was it a case in which the issues raised clearly gave rise to such significant potential detriment in European Convention and UN Convention terms as well, that a more involved process was necessarily appropriate.
Oh, sorry. No.
Well, did anything else I can say to assist in explaining our appeal?
Yes, thank you very much.
Thank you.
Yes, Scriptor.
Your Lordship, yes. Obviously, you have our scheduled submissions on the main appeal, and we've put them in two parts, the mother's appeal and the response to the father's appeal. I was just going to ask the court to have a look, please, at page 230 in the main appeal bundle, because in my submission, it's worth providing context to the hearing on the 13th of May.
2:30.
2:30.
Yes.
This hearing is the 28th of April. This is where the father was representing himself together with Miss Gillard helping him. And it's after, of course, your Lordship's decision to refuse permission to appeal the January decision. And at that stage, the father is saying to the learned judge, the same judge who dealt with the matter on the 13th of May, Sir Jonathan Cohen, at paragraph C,
Yes.
regarding the jurisdiction of my lord, I accept completely. I understand the jurisdiction of this court is very, very limited, but this court can make orders on the welfare of the child. And then further down, this is after, of course, the learned judge has started to say to the father, well, my jurisdiction's quite limited here. Further
Where's
down,
what? Sorry, where I missed.
so 230 is
I've got that.
yes. And further down,
Yes.
Miss Gillard at 234. This is what the father's position was.
234.
234. Miss Gillard again at paragraph C. I think Mr. Xanthopoulos is asking the court to do his very small jurisdiction window that you have. He's not suggesting he wants to relitigate the case. That has been heard and decided. Talks about the war being intense. Then further on, paragraph where it says F in the margin. And of course, naturally, it obviously does not want her to go. This is, of course, child 2. But he's accepting she will go because of your ruling and because he's lost in the Court of Appeal. What he's saying is it should be orderly, there should be a transition, it should be respectful, etc. That's the 28th of April. And his lordship 239 in his decision at paragraph 9 says she had a normal life, she has play dates, completely socialised, loves her school. He's summarising the father's position. I consider them when I made my finding as to habitual residence, but time has moved on, decisions have been made. There's no good ground for me to revisit it, not that father asked me to revisit or defer its implementation for a long period. Then, of course, on the 12th of May, he instructs a new firm of solicitors. And a bespoke hearing, as Your Lordship, Lord Justice Jackson pointed out, was prepared at short notice by the learned judge. And we say, and I've set it out clearly, we've set it out at paragraph 15 of our skeleton submissions, at page 13 of that document, was that he dealt with the matter in a fair way, a firm way, but a fair way. It was convened at short notice. We were notified at about 4 o'clock the day before, and the hearing took about 2 hours, as Your Lordship pointed out, at 2 o'clock in the afternoon. You'll see from the documents that were provided, if you look at the position statements of my learned friend Mr. Devereux, Queen's Counsel, that can be found at a 5-page detailed document at page 324, and my bullet point document in response, hastily prepared in the afternoon and sent through about 5 to 2 on the subsequent pages 329 to 330. I didn't address His Lordship on whether he actually had a power to set aside his decision, the matter having been to the Court of Appeal and refused, the appeal having been refused. Didn't concede it, but didn't address it. Just dealt with the merits of it. What Your Lordship has just seen at 3B, step A, the first step. Does it get off the ground? You'll see when you go through the transcript of the hearing, about 45 minutes into that 1-hour hearing, Mr. Devereux is told, well, you've taken 45 minutes now. My submissions and response then took over for not that long, because His Lordship was very clear that as far as he was concerned, he did indeed have a very limited jurisdiction. But I was not saying that his jurisdiction on the set-aside was limited, I simply didn't address him on it. And you've seen in our submissions what we're saying about the legal framework for set-aside. It may be a matter for the Rules Committee, page 15, paragraph 21 onwards. There is, of course, something this court may want to say about the policy of allowing a domestic High Court judge to be able to say, well, no, hang on, something major has happened here, and I should have some residual power to look at matters again. But then there's this international aspect, we say, because it's a 1996 Hague Convention case, and a welfare-based decision has been made by a foreign country, recognised and enforced by the learned trial judge, and then the appeal has been unsuccessful. When the matter comes before that same puny judge on a set-aside application, we respectfully submit that different pressures apply. An international outlook needs to be considered.
What's the international outlook?
Well, the very fact that this country is a signatory to the 1996 Hague Convention and decisions being made.
What's the effect of recognising a foreign order?
The effect is to enforce and accept that that foreign court has made welfare-based decisions based on.
Is it essentially to treat it as a domestic order?
Effectively, yes, but not to subvert that.
But if it's a domestic order, a court would have power to vary it.
Yes. Well, Your Lordship.
I mean, do we not go? I mean, because it's not. It doesn't have some magical status because it's an order made by a foreign court. This court, in this case, decides that it should be recognised. Decides also that it should be enforced.
And renders it a domestic reflection of that.
Isn't that the effect of it?
Well, Your Lordship can see why and this has happened in previous, in a 1980 context, when it comes to set aside, intellectually one has a difficulty saying there is no power to revisit.
Yes, I mean 1980 is different because that's not the court, as the court making a freestanding order, not making or recognising a parental responsibility, a welfare order. But the 1996 is recognising what I'm describing as a welfare order.
Yes.
So I would have thought there's a good argument for saying it, if it's being treated as a domestic, in the same, as though a domestic order, that includes the court's powers, general powers, to vary orders made under the
And imports that.
And imports that.
Yes. Well, Your Lordship, we respectfully submit that going back to paragraph 89 of Re B, which is in our authorities bundle, which you've just looked at, page 135
Yes.
of that authorities bundle, that His Lordship did, although it wasn't pointed out to him, that authority did effectively conduct that exercise at A. The court will first decide whether to permit any reconsideration. The case was hastily prepared by the father's new firm of solicitors and new counsel, but adequately, more than adequately prepared, if I may say so. Looking at the statement and the exhibits that were attached, looking at my learned friend Mr. Deverick's Queen's Counsel's position statement, and as bespoke hearing was set up. And if one looks at the actual judgment,
I'm very sorry to interrupt.
Yes.
You started to talk about jurisdiction, and now you've gone back to the substance of the case.
yes.
Are you going to talk any more about jurisdiction?
Well, I can if Your Lordship invites
No,
me to.
I'm
We've set it all out
Yeah.
in the skeletal submissions that maybe this is something for the Rules Committee effectively. Maybe it's something for this court to say, well, intellectually this does exist, or policy-wise it shouldn't exist. We say that because we didn't raise this in the court below, it is an issue that the court may want to deal with, or say no, not in this appeal. Because we say, of course, the judge in the court below dealt with it properly.
Well, I mean, I read all of this with very great interest.
Yes.
But I don't actually see anywhere the proposition for this reason, or on the basis of this authority, there is no jurisdiction to set aside.
We couldn't say that.
No.
We couldn't
I mean,
say
you
that. I
come
didn't
down
raise-
to
As I said, I didn't say that in the court below.
no. You come down to saying, well, the application should be made promptly,
Yes.
and it needs to demonstrate material change of circumstance, brackets of significance.
Yes.
But
It's
as
a
long as-
realistic approach, if I may say so,
Yeah, all right.
to this type of application. And we say, nevertheless, if one does import, for example, the decision in Re B in 1996 Hague cases, as much as other kinds of cases, 1980 cases, Hague cases, then the first step is, will the court decide whether to permit a reconsideration?
Yeah, all right.
That in different wording is what the learned judge in the court below did.
Right, sorry, I interrupted you.
No, not at all.
Go into the substance of it.
We were just trying to show the court that we thought this through, this process. And there is potentially an argument, but we're not mounting, we didn't mount in the court below, and it may be this court can clarify that. Looking at the actual decision of Sir Jonathan Cohen, which is of course at page 70 in the bundle. If I could just highlight this, paragraph 2. The interim prohibited steps order to prevent the mother from removing Sophia from the jurisdiction. That was one of the applications. He dismissed that application, whilst at the same time holding on to the passport, ordering my instructors as effectively to carry on holding on to the passports. My client through me today would like to apologise for not being here, but she felt extremely frustrated by what was happening. Father 1 minute saying in the hearing in April, I don't question this order, I don't question the fact that I've lost in the Court of Appeal, and yes, it's just a matter of how a child is going to go, but then at the same time raising this issue on the 13th of May. Sorry to jump around, but if the court looks at a letter, which is the last document in the supplemental bundle, 19th of May letter, page 106 in the supplemental Court of Appeal bundle.
106.
106. This is a letter written by a gentleman in front of me, Mr. Allison, who's the solicitor for the mother, my instructing solicitor. And it's dated the 19th of May, sent by email to father's then solicitors, Mr. Carruthers. Very clearly sets out what happened. Taken child 2, gone to Russia, and then sets out proposals, indirect contact, and of course, direct contact, saying, come over. Now, this is a country, of course, the father's lived in for many years, I think it's about 20 years, has a Russian passport. And I gather there's been some indirect contact, not as much as has been offered, but of course, the father's staying away. Going back to...
So why are you drawing attention to this?
I'm drawing attention to this because of what's been said by my own friends, Tyler Queen's Counsel, on behalf of the mother and father, which is that the mother's blocking contact and has not provided...
So a situation in which you take your 5-year-old out of the country, don't, for reasons which seem good to you, say you're going to do it, leave aside whatever orders were in existence, communicate after the event through solicitors. You're drawing that to our attention to show the general reasonableness of your client's approach?
I can't say she's being reasonable, but I'm saying that she's being transparent as much as she can be.
Yes, but I mean, this sort of letter, with all due respect, is window dressing. Right.
Your client was aware of the order that I had made
Yes, indeed she was.
when she left.
Yes, she was. She was aware of the order. She was aware, of course, as I pointed out from the judgment, that the court had before it an application, as I mentioned in paragraph 2, prejudice debts order, which it had dismissed at the same time. But after litigation spanning over 2 years, after being in this country with her children for 2 years, effectively, since September 2020, having had the decisions from the Russian court and the decision from this court upholding the Russian decision from March 2021, she'd come to the end of her tether.
Are these set out in your client's witness statement, these matters?
She has set out in that
She took
statement,
into account
yes.
the dismissal of the application for the interim prohibited steps order, or are these submissions?
She, not words to that, words to that effect, she's saying that she didn't have any orders against her from leaving, and she wasn't
Right.
in breach of any order as far as she was aware. So that statement can be found at page 15 of the supplemental bundle,
Yes.
paragraph 1 onwards at page 16. I invite the court to read that in due course. But going back to the actual decision of the 13th of May, we respectfully submit that the learned judge conducted a very controlled and clear analysis of the father's case, coming to the case as he did with an inordinate amount of experience for a particular family that had come before him. Bearing in mind the hearing that he conducted in December and January of the earlier the year, the fact that the money proceedings, of course, were in front of him on occasions, and he was able to look at what the father had said in front of him in April, and I pointed out the transcripts, but also the bespoke evidence that had been placed before him. And in Marasuk's submission, he went through it in detail. Of course, the judgment in the January decision deals with it in far more detail. But the question for this court is whether his swift approach was wrong. Is it a cursory approach? We respectfully submit no. He tried his utmost to set out a hearing. It was listed for 1 hour, went on for, I think, over 2 hours, and looked at the father's reasons and reasoning for mounting a case to set aside when the same gentleman being in front of him on the 28th of April had said, I will accept this decision.
The submission that's made, as I understand, is what it might be summarised as sort of access to justice and the consequent effect on the younger child's welfare. And Mr. Tyler submits that the judge was not in a position, or that his conclusions in paragraphs 10 and 11 were flawed because he was not in a position properly to reach those conclusions. For example, I do not accept that father, is at any particular risk, nor am I persuaded at the moment that there is or could have been put before me any evidence that his access to Russian courts is hindered. And in paragraph 11, I do not accept that there is any restriction on the father visiting Russia, etc. How do you respond to those submissions?
Well, we respectfully submit that these are exactly the kind of complaints that the father made earlier in the year, in December of the previous year. They were considered in the compendious judgment of January, and there's no third-party evidence apart from something off the internet that the father could produce. It was asked earlier on by Justice Davis what would happen, what was the father going to gather? And it was said that he would gather more evidence to substantiate his assertions. We respectfully submit it was all there. As my own friend Mr. Tyler had explained, in the judgment in January, if I can just turn it up. In the judgment in January, which is at page 144, he sets out father's assertions at paragraph 122. And at 120, of course, he says it's not proper for me to take into account, Mr. Tyler, as Mr. Tyler asks, unrelated internet articles of general supposition. Russia is a signatory state to the 1996 Hague Convention, and unless admissible evidence is presented that enables the court to overcome the high statutory hurdle set out in the Convention, comity requires that the order should be recognised. As I set out in the bullet point of my very short position statement on the day for the 13th of May, nothing new was being presented. I said very clearly nothing's changed since the 14th of April when the Court of Appeal refused permission to appeal. Now, of course, if one stands back for a moment and looks at the conflict in Ukraine, Russia invaded Ukraine, I think it was 24th of February 2022. So all the information that the father was trying to place before had been there for some time. Of course, it was there on April the 28th when he attended court in front of Sir Jonathan Cohen on another matter. And yet it's all raised at the last minute, hours before the mother's due to depart. And we respectfully submit it was done in a planned way because the father was simply trying to have another bite at the cherry, a third bite at the cherry, by raising issues that had already been considered in the main judgment.
What was the planned departure date?
Planned departure date was, I think it was the 8th, it was Monday the 16th. Is that right? Monday the 16th was the original departure date. Yes. Originally, I think it was the 28th or so of April, 14 days after the Court of Appeal had refused permission to appeal. Then that was extended to Monday the 18th. Father attends court, of course, on the Friday.
Sorry, just walk through this, would you? A certain time period expires on the 28th of April.
Yes, 14 days after.
Yes, and however, departure did not take place then because the passports?
Because the father attended court on the 28th of April, and the learned judge said, well, let's delay this till the 18th of May. Sorry, 16th of May, Monday the 16th of May. Direct contact to take place. And then just before the weekend, on Friday the 13th of May, father attends at 2 o'clock in front of Sir Jonathan Cohen.
Right, so it's the Friday before the Monday, you say?
Yes, Friday before the Monday.
The Monday already being a deferred date.
Yes, indeed. And the learned judge listed and heard the matter, considered the documents that were before him, and we say did it fairly, and without reference to REB, but actually was correct in his process and analysis. Looking at what was said earlier on about what should happen in the real world, effectively, if the the father's appeal is allowed. I was interested to hear the father's case would be for an order for child 2 to be brought to England. And when enforceability was raised, it seemed that the part 3 proceedings would be brought to bear. In other words, money would be, there would be some financial incentive to the mother to avoid the father enforcing it that way. But what was not mentioned was a 1996 Hague Convention application in Russia. And there's a reason for that, because of course this court has already recognised and enforced the Russian decision. We respectfully submit that that's a non-starter for the father.
Well, why? Because the father's made a Children Act application in this country, which predates your class application in Russia, new one.
We'd respectfully submit that it would be open to the mother to say no, to question the enforcement of it, and say that it's manifestly contrary to public policy in Russia. In other words, another round of litigation in Russia.
What possible basis?
Well, she would raise the very fact that the Russian court has made decisions about the child living with her wherever she wants to live and in Russia. And if the father's seeking orders, welfare-based orders for the child to be in this jurisdiction, then they would potentially be contrary to the Russian decision.
That's the whole point of 1996. You can get different decisions in different contracting states at different times.
Yes, indeed.
It would be frankly bizarre if that was treated as manifestly contrary to public policy.
What I'm trying to say, Lordship, is that there would be potentially enforcement proceedings in Russia.
No, well, it was just when you said this court had no jurisdiction, and you seem to your submission seemed to presume that the Russian courts, the proceedings of the Russian court, would take precedence under the dispender's provisions, and that is a step further down the road.
No, I'm presuming there would be litigation in Russia, and these children, this child, B, would be, we've used the phrase, further mummified in red tape.
Yes.
And that just can't be right in this scenario, or in any scenario. There has to be a continuum, and we say that the context of how this matter comes before you should be borne in mind, and that the mother's position is consistent, and we respectfully submit compelling, of course. And the learned judge in the court below has given a lot of time over the last year or so to this family, and that the 13th of May wasn't just a one-off hearing it was part of that continuum. He came to this matter, came to the father's application with a whole bank of knowledge of how he'd run his case, all the matters that had been raised that weren't in the learned judge's judgment in January, but of course were no doubt considered by him when he came to his decision. And so for the father to say, well, hang on, there's something more now, well, the learned judge was right to look at that with a critical eye, fairly, but deal with it firmly. So, Your Lordship, what I was going to do after the short adjournment was to address you on the mother's appeal and the fresh evidence application.
And how long do you think that will take?
Half an hour, because we're building our appeal of those paragraphs 2 and 4 of the learned judge's decision on what we've said about the lack of jurisdiction, domestic jurisdiction over the children, over the child.
Right, thank you.
That's the first half of the skeleton submissions.
Yes.
Going to page 30. It's first 13 pages.
Yes,
Thank you.
thank you. So we'll stop now and start again at 2 o'clock.